Hello, I'm Nestor Wagner. This is lecture number 4 for the preparation for the written state examination. This lecture deals specifically with one area called professional conduct and ethics of the interpreter. There's no class material for this lecture, so I strongly suggest that you take notes and that you download the ethics manual published by the Judicial Council of California, which is one of the requirements, and that you read that ethics manual. The question on professional conduct and ethics are questions that basically puts you in a court of law and puts you there in a given scenario, in a given situation, and you are the interpreter, and you have to decide what will be the best course of action. There is a lot of common sense in this one, a lot of common sense. So if you don't know an answer to a question, let me just tell you right now, common sense should prevail. Okay, so look at the various answers and look which one makes more sense. And that common sense has to be based on the fact that you don't call the shots in a court of law. The judge calls the shots. Furthermore, anything that you need to, as the interpreter, need to disclose, if it's something you're going to disclose, it has to be disclosed not only to the judge, but also to the both attorneys, both parties. So if it's procedural, it should be always, the answer should always have to do with the judge. For example, if the question is, you're interpreting for an expert witness that was brought in from a foreign country. Okay. The expert witness used terminology that you are unfamiliar with. What are you supposed to do? A, do your best. B, create words that don't exist. I don't know. Some answers are very straightforward. If I have 4 answers, I'm going to be looking for one that involves the judge, because this is a procedural thing. So most likely tell the judge. Now, sometimes if you don't see that in an answer, tell the judge, then you have to keep in mind that the person who is closer to the judge in a court of law is the clerk. So if the answers do not have the judge, it says tell the clerk, but it doesn't have tell the judge as one of the options, then you use notify the clerk or tell the clerk. But if he has the judge, that takes priority. If not, look for the clerk. When it is procedural. Procedural means anything that has to do with something that can affect the record. Like in this case, if I don't know the terms, that's going to affect the record because I'm going to be misinterpreting. However, when it has to do with disclosing something, like for example, I'm going to interpret for someone who plays soccer with me. Well, I have to tell the parties that I know that person and that we play together in a soccer team. But is it the parties or the court? Well, it's the court, because the court is in charge of the record. So the court is in charge of the record and future appeals, meaning that if I don't disclose that, that could be a ground for an appeal. And then I have to tell both parties, so that way an appeal is prevented, because those parties have to decide whether I should interpret or not. So it's the judge and the parties when you disclose something. Disclose something that has to do with basically conflict of interest, or what could be perceived as conflict of interest. And if it is procedural, it's the judge, and if not, the clerk. If you know this, and then you put common sense, in any answer, that's all you need to know, because that's what ethics and professional conduct is all about, right? It's just common sense, basically. However, we're going to look at some examples, and what I just explained is for those questions that you have doubts, you don't know what would be the right answer, so you analyze each of the answers. And then you follow those tips, and that will most likely will be correct. You will do very, very well. Now, of course, there are some other scenarios or some other situations where, for example, let's look at this one. Let's say, for example, that it says you interpret for a witness at 10 a.m. At 11 a.m., you in a trial, okay, 10 a.m. in a trial. At 11 a.m., the judge calls for a break in this trial. You go into the elevator and you notice that one jury member is also there, the jury member decides to talk to you, ask you questions about interpreting. What are you supposed to do? Now, you're in the elevator. You can run. So the options here, the common sense is that you shouldn't really talk to a jury member or a member of the jury while the case is being being presented in court. So I don't know what options they will give you, because this is not about giving you options, but rather making you understand how to decide which one is the right option. But one of the answers should definitely be don't answer, maybe that. Or politely say that you cannot talk, or just simply say no comment. You know, I don't know which ones they have. They are not going to have answers that can be two answers that can both be correct. Like, for example, if they say A, the interpreter should say, sorry, I have no comments. B, the interpreter should keep quiet. I mean, any of those will be correct answers for this. Because the bottom line is that you don't want to be perceived that you have a communication. Of course, you may say, wait a minute, there is nobody else in the elevator. It doesn't matter. It really doesn't matter. It's not who's present, it's what you're not supposed to do. It's called professional conduct. Now, obviously, if you are in front of a crowd in a hallway and then they approach you, anybody who's a juror approaches you, clearly you don't want to talk, or even a defendant or a witness. Because you have to remember that the interpreter, this is another important tip you have to keep in mind, the interpreter is completely isolated from all the parties. We shouldn't give the impression that we are either for one or the other party. We're neutral. In fact, the court reporter, the bailiff, the clerk, the interpreter, and the judge, we are all neutral. Then the attorneys, they have sides. And then witnesses, they have sides. The jury is neutral. If it's not neutral, then you have to challenge them. Because if they are not impartial, then you have to challenge them, either for cause, well, it will be for cause, or because there is a cause for you to believe that that particular jurors or that particular juror cannot decide a case impartially. So all these questions really are based on common sense, but the common sense is based on what we can do. So let me explain what we can do as an interpreter and what we cannot do. Number one, we cannot communicate with any of the witnesses, defendants, or anybody unless we're asked to interpret. Only interpreting. We cannot be talking to the defendant. Say, for example, that the jurors are already in the jury panel, the judge is not present yet, is in chambers, and you start talking, and you are there with the defendant, and the attorney is, let's say, talking to the prosecutor, and you start having a conversation with the defendant, and the jurors are looking at you. That is a violation of our code of ethics. We cannot communicate with anybody. So what happens if they give you a question like that? What are you supposed to do? Then you just stand and leave. Be at a distance. Get closer to the defendant once the judge is in the courtroom. Don't give the idea, there shouldn't be any perception that you somehow take sides. That's important. So all questions that are related to that, that's the answer. Look for the answer that matches that. The other thing is that we need to disclose anything that we think could be a conflict of interest in terms of the relationship that you as the interpreter have with the potential person, witness who you're going to be interpreting for. And that's, of course, a disclosure that should be made to the judge and to both attorneys. Should that be made to the jurors? Not necessarily. If you know that a witness is going to testify before the jurors go to the jury box, and you know that there is a potential conflict of interest there, then all you got to do is just tell the clerk, most likely the judge is not present, and then tell both attorneys. When the judge comes in, the judge will probably ask the bailiff not to bring the jurors into the courtroom, and the judge will basically say, I have been informed by my clerk that the court interpreter assigned to this department knows the witness that he is instructed to interpret for, for the next 40 minutes. The judge will look at both attorneys. Any objection? But this is all on the record, so that prevents any type of an appeal. So we have to disclose this to all the parties. And of course, if it's a procedural issue, like I don't know a term, you tell the judge. Your code of ethics for the state of California will tell you if you don't know a term, you can ask the judge permission to even look up the word in a dictionary. And that's the answer you should give in the exam. That's not what I would advise you to do in real life. If you don't know, you may inquire. Your Honor may the interpreter inquire. But you know, sometimes they ask a question like that. What are you supposed to do if you don't know a term? Okay, one, look it up and ask the judge permission to look it up in a dictionary. That will be the answer. The other interesting thing about this particular professional questions on professional conduct is that sometimes what the code of ethics says is not necessarily what is good in real life. For example, if you cannot hear the judge, you're supposed to speak up. So if you have a question there in the exam that says if the interpreter cannot hear the judge, what is the interpreter supposed to do? Tell the judge that you cannot hear. If you cannot hear a juror, tell the juror. Why? Because you cannot interpret if you cannot hear. In real life, you know, it's different because you can't be interrupting the judge and everybody every second. So there are different ways, and I discussed that in the class, in various classes. But for the in the criminal 1, 2, or site, and even in advanced criminal 2, we talk about this. But for the state exam, for the written exam, it has to be all by the book. So if you cannot hear, you got to speak up. Okay, tell I cannot hear. So keep that in mind. Those four, I call them sort of 3 principles more than anything else. Number 1, disclose any type of conflict of interest to all the parties. I think there are 4 principles. Number 2, do not communicate with any party unless you're acting as an interpreter and you have an attorney for that party there. You can't be, what you don't want is the jury or a juror to see you and another person talking. I mean, if there is an attorney, you and the other person, then you're interpreting, yeah. But just you and that person talking, no. So that's why we try to be always away from potential witnesses and even from the from the defendants in the various cases. Okay, because we are a single unit that can only come into play when the attorney is asking us to do something, but not out of our own initiative. So that would be principle number 2. So again, number 1 is disclose any type of potential conflict of interest to all the parties. Number 2, be completely isolated. That means only participate when an attorney asks you to participate and not voluntarily have a conversation with any of the potential witnesses or the defendant. Number 3, if it is a procedural issue, then you need to tell the court. And that is the judge. Don't disclose it to the judge and the parties, which is both attorneys. That's for conflict of interest. But for procedural issues, you disclose that to the judge. And if the judge is not present, to the clerk. Okay? The clerk is always sort of the representative of the judge when the judge is not present. Okay, those are basically 3 main things. You can say that the 4th one has to do with your ability to hear and to interpret. In other words, the 4th principle should always be you cannot interpret something that you cannot hear. Neither can you interpret something that you don't know how to interpret. So the answer to those questions is if you cannot hear, speak up. Tell the party that you cannot hear. And if you don't know a word, the answer is ask the judge permission to look it up in a dictionary if you have one. If you don't have one, ask the judge permission to inquire. Your Honor, may the interpreter inquire. That way, that question, that permission, that gives you permission to establish that communication directly with the witness on something that has to do with linguistic issues. So it's okay, because the judge authorized you to do that. Okay? So those are the 4 principles. There is a quiz that I want you to take, and I want you to look at all the different options there, all the different, follow these 4 steps, 4 principles that I just mentioned, and then go over the quiz and see whether you score well. You may not need to read the whole code of ethics, although it will not be a bad idea, as a matter of fact. particularly the area in the Code of Ethics that deals with neutrality, confidentiality. Those are conflict of interest. You know, those are very important sections. But I would strongly suggest that you just do the quiz, see what grade you get. If you successfully pass it, I would say that you don't need to actually read the Code of Ethics, or you can only review it. But if you don't pass it, then go to the Code of Ethics and review it again to make sure that you understand a little more the concept of professional conduct in a courtroom. Okay? This is the last lecture for the preparation for the written state exam. So this basically ends this course. Once you finish with this quiz that you have to take on professional conduct and ethics, I would strongly suggest that you go to all the other quizzes, lecture 1, the quizzes in lecture 1, lecture 2, lecture 3, lecture 4 even, and take the quizzes a few more times. And your goal should be to score as close as possible to 95 to 98%. So you can miss only a couple of terms, okay? Just go over it and review as much as you can so that you're better prepared for the exam. And I wish you the best of luck when you take your exam. Thank you.